Welcome to Quarter Protection Briefs. This video is about fluctuating capacity. Judges don't get to decide how difficult their cases are, straightforward or a minefield. They just have to get on and decide to make a ruling as best they can. Fluctuating capacity is one of those areas where judges have struggled. It tests the limits of the court's jurisdiction and principles. The dictionary definition of fluctuate is to change a lot in an irregular way. The idea of functioning at different levels at different times, sometimes worse, sometimes better, is something we are all familiar with. That's why chocolate bar maker Snickers have made some fantastic commercials about it.
Can we turn the AC up? I'm dying back here.
It's on. Can't you feel it?
Can you feel that?
Oh.
Jeff, eat a Snickers, please.
Why?
Every time you get hungry, you turn into a diva. Just eat it so we can all coexist.
Turn into a diva.
The new system, crappy pants.
Okay.
Thank you. Better? Better.
Will you get your knees out of the back of my seat?
Oh.
You're not you when you're hungry.
Of course, the Court of Protection doesn't need to get involved when we get a bit Aretha Franklin or a touch Liza Minnelli when we're in need of an energy boost. But it does when the differences in our levels of capacity affect our ability to make important decisions, affecting us and those who come into contact with us. Capacity in legal terms is generally considered in quite a binary way. While consideration needs to be given to specific decisions and supporting people to make decisions, people are generally assessed as having capacity to make decisions relating to health and welfare, property and finance, or assessed as not having those capacities. What is the court to do when sometimes you do and sometimes you don't? The Mental Capacity Act doesn't help. The Code of Practice says that in a situation of fluctuating capacity, P should be supported to make as many of their own decisions as possible. Sound in theory, more difficult in practice. In terms of the court's decision, it seems like an area where it's still working out a consistent, reliable approach, but it's getting there. There are generally two ways of dealing with it. When it is clear what times P has capacity and does not have capacity, anticipatory declarations can be made by the court. An anticipatory declaration makes lawful decisions made, potentially to be made, at some point and under certain circumstances in the future. They cover situations where P currently has capacity, but is expected that at some point in the future they will not. In this case, the anticipatory declaration will address how, when P does not have capacity, their freedom can be restricted in a way that is necessary to safeguard them and others. In other cases of fluctuating capacity where it's not clear when someone does and does not have capacity, the longitudinal approach is used. If you cannot say at any moment whether someone has capacity or not relating to the decisions they make, it is impractical to continuously reassess capacity, to run to court for rulings, so this person is treated as not having capacity, supported to make as many decisions as they are able, but treated as not having capacity, even though they sometimes do have capacity. It is an approach dictated by convenience, perhaps necessity, but it does not sit comfortably with the court's principle. Let me illustrate that. Jane is at the border of capacity. She drifts either side. Objects sometimes talk to her, but only sometimes. The wardrobe, the light fitting, the floor. It's cold outside and Jane is getting ready to go out. When the carer comes into the room, Jane is wearing a thin old-fashioned jacket, quite unsuitable. What is the carer to think, to do? Today it might be that the voice in the wardrobe is telling Jane that unless she wears that jacket so it's clearly visible, a taxi driver in Guatemala may have a terrible road accident. Jane doesn't want a taxi driver in Guatemala to have a terrible road accident, so the thin jacket is on and it's going outside with her. But what if it was her grandmother's jacket? Jane was thinking of her grandmother that morning and wants to wear it to remember her, to feel close to her. A lovely thought. She's quite happy to put a coat over it. That can be the same Jane on different days. Hopefully, the carer will have the time and skill to explore why Jane is wearing her thin jacket that day, to simply put a coat over it on the lucid day, or maybe drape it over her coat on a day the voice in the wardrobe is active. And there are situations where neither the longitudinal approach nor use of anticipatory declarations fits. I know because I've encountered them. What then? Let me go through the approach I took. This is not a setting out of a legal test endorsed by the court. It just goes through my thinking on a particular case. Stuart loses control immediately, impulsively, without any warning, and when he does, he is an immediate danger to himself and others. It's no good saying once Stuart becomes dysregulated, once he loses capacity, restrictions can be put in place. It's too late. Stuart or someone else could be dead by then. Even when he has capacity and is navigating the decisions of daily life without issue, he needs to be near support, just in case. I considered this could be resolved by going to the fundamental provisions of the Mental Capacity Act. As well as needing to understand the relevant information, to retain it, use or weigh it, there is a sometimes underappreciated requirement to recognise the foreseeable consequences of the decision. In this case, it could have been said it was foreseeable if Stuart did not have support in place ready for when he became dysregulated, he and others could suffer serious harm. As a consequence, it's a fundamental part of his capacity assessment. He needs to agree to being supported when he has capacity for the eventuality that he loses it. If Stuart is not able to recognise that foreseeable consequence of needing the support, of consenting to the support, it could have been said he does not in fact have capacity because he's not facing up to the foreseeable consequences. He cannot take them into account. But that's not an approach that I've seen tested. We may not all hear the voices in the wardrobe, but fluctuating capacity is a relatable area of the work of the Court of Protection because we all know that sometimes we function better than others. And we may prefer to keep it to ourselves, but we all experience moments where we're so overwhelmed by what the world is throwing at us, we're not at all confident in our own ability to make decisions. That's it for this video on fluctuating capacity. For what mental capacity means, how it's assessed, when it's lost, have a look at the other videos on this channel and subscribe or watch out for the next video from Court of Protection Briefs.